So my name is Jonathan Norman. I'm the team chief for the education advocacy team here at the Legal Aid Center. Prior to moving into this position, I was a cap attorney in the West and ICWA courtroom, so Judge Tootin. I'm joined by Bridget Duffy, who's the Chief Deputy District Attorney and the Director of the Juvenile Division. Mari Parlade, Esquire, she's the Legal and Strategic Initiatives Manager at the Clark County Department of Family Services. Dr. Leslie Strasser Murdock, who used to work at Legal Aid in the Education Advocacy Department, and we still use some of the material that she developed that is still relevant today. And she's the educational liaison for the Clark County Department of Family Services with the school district. And Ilka Fisher, who's a member of our education advocacy team. She's an education advocate coordinator who works primarily with the volunteer education advocates. So welcome everyone. Obviously try to keep your mics muted if you're not talking. If you have questions, throw them in the chat or just save them till the end. Probably a lot of the questions will be addressed as we go, so we're not going to stop to address the questions until the very end. The first thing I wanted to talk about is, why education advocacy matters so much for our kids is they have so much other baggage that other kids don't have. Not just, the things listed here, but if you think about the idea of uncertainty, during COVID, all our lives have been a little uncertain, whether we're working at home, and to see how we've all struggled in dealing with that little bit of uncertainty, and then thinking about our kids who, may not know when they're going to be able to see their parents, siblings, may not know where they're going to be living this week or in several months. They just have a tremendous amount of other things that can set their education back. And I think that's why it's really important to focus on education.
Absolutely. Education is the key to opportunity for our kids. As we know, there's so much flux, so many changes, so many things. But the one thing that our kids have is the education. It's so much more than grades and classes. It's support systems, it's peer networks, it's relationships with teachers, mentors, friends, their peer group, their identity. So much, as we know, our kids, they're going through so much flux, and they're going through not just changes in their growth, hormones, all of that, but education is so much for our kids. And in the child welfare side of the house, we focus on three things, right? Safety, permanency, well-being. Well, education is such an integral part of their well-being, and it's amazing to see that we have all sides of child welfare, whether you're a district attorney, children's attorney, CASA, child welfare worker, or even parents attorney. I don't think any of us will disagree that education is so important for our children, and whatever we can do to move the mark, to wrap them in the right level of support and to advocate for them, it's going to go a tremendously long way, far beyond what the here and now for our kids. We can go on to the next slide. And that kind of leads me to the school mobility piece, because as we know, our foster kids, they bounce around sometimes from home to home, or from initial home to foster home to fictive kin to relative, and everywhere. And that's where the school mobility and the education piece is so integral, because I know I'm preaching to the choir here, but I mean, each time that our kids are moving, it's impacting their development, it's impacting their relationships, impacting their emotional stability, behavioral stability, not to mention their classes and their school. And again, with so much flux, we're looking not only at ways that we can ensure the education for our kids, but also ensure the educational stability for our kids, so that they don't have to move unless it's against their best interest. So that's where I think I'm excited about the CLE, because you've got the best of the best here to just impart so much knowledge and opportunity for us to make a tremendous difference in the lives of all of our children that we represent.
So in 2015, President Obama signed the Every Student Succeeds Act, which went into effect in 2016. The next slide here, these are some of the rights that were included in that act. Some of them come from other statutes and laws. Here, I wanted to point out that these are all things that our team can act immediately on, working with Donna at the school district and working with Leslie. So these, we don't even have to have an open case to address these issues. A good example, we recently had kids that came into care. They were from out of state and they were just traveling through Las Vegas. They were taken into care, and the school didn't want to enroll them because there were some records missing. So they missed the first day of school. Our team found out about it and were able to get those kids the enrollment solved right away, so they weren't missing school. And you know, the key to everything for me, when I took this position, you know, Kelly Vinci was in this position prior to me, and she left, you know, somewhere in her office, which I moved into, just a note that said, whenever you're in doubt about what you're doing, it should be focused on getting kids in school and keeping them in school, right? So with this slide, you know, all these things are stuff that we can act on right away. We don't need to go to court to get this stuff. We can just, you know, resolve it with some phone calls. Leslie, can you unmute yourself?
Absolutely.
Okay.
So it's been really wonderful, and I have to give kudos again to the Legal Aid Center that a lot of you guys are associated with or volunteering with, because I will say that the Legal Aid Center has done such a great job of advancing certain things for our kiddos to really recognize the fact that not only obviously a lot of our kids struggle academically and with everything going on at school, but really understanding the unique circumstances of children in care. And so one of the exciting things again is that at least at the elementary school level, as well as at the high school level, there are we have academic plans that actually look at not only recognizing unique circumstances and taking that into account as we're working with our kiddos, but also trying to maximize, knowing that, you know, when our kiddos are struggling, to maximize credits to keep them moving in the educational system and remove barriers. So it's really exciting that we have special laws in Nevada that push those things forward, that take the ESSA and then actually move forward even more with our state laws trying to take care of our kiddos. So there are academic plans, again, at the elementary school, the middle school and the high school level to help move our kids forward and making sure that they either promote, they have the skills, or that they're able to, again, move towards graduation and getting out there into real life. So what's again unique to Nevada, which is really exciting, we do have an elementary school academic plan for our kiddos. And this is only specifically for children in care, which is really exciting. I wish we could have this for all of our kiddos, but we definitely know that our kids need this plan. So the nice thing is we've been working for years and years with the school district, and it's wonderful with the elementary school counselors. So there is supposed to be an academic plan for any child that's, we're informed, is in foster care. We are supposed to look at the unique circumstances and educational background of the kiddo and try to put goals in for success. The plan, again, to the point, and I don't want to read off of the entire slide, but the plan must be reviewed and revised each year to look at where our kids are currently and what supports we need to make sure that they're moving forward in their academics and moving forward towards the skills that they need to continue to be successful educationally. So Ilka, if you want to go, okay. And then the academic plan, so it does include, we look at the reading, writing, and math categories. It's important to get a better sense, kind of a snapshot as to how the kiddo is doing. So looking at their strengths, looking at their weaknesses, and then again, putting in a goal for each one of these areas. Where do we want them to be in about a year from now? It does have information on whether or not the child has certain types of records. So it's a great piece of information. These right now are housed at the moment in a paper copy in the child's hard file. So again, for anybody that needs it, that's where they are. We're working on trying to get it into Infinite Campus, but right now we just have not had a chance to do that. So it is something, a school record, that can be requested via the school to look at and help determine programming and also making sure that our kiddos are moving forward. There is a recommendation again that they invite DFS and invite, of course, which we'll talk about, our EDMs and folks involved in the child's education to really make this meaningful. When they first passed this, it was funny, the Nevada Department of Ed put this together and they forgot to actually put the child's name on the academic plan. So we have moved forward in that direction and really given it some nice input in there that can help put together programming for our kiddos. So at the middle school and high school, this is again, the goal of middle school and high school is promotion to the next grade. So in this particular plan, we do not have anything specific for our children in care. However, we are putting together goals for courses, for any sort of education, anything that will continue to advance our kiddos through their education, and also what, again, what are expected of the teachers in the school to move our kids forward. And then finally in ninth grade, again, what the requirement is in Nevada that we put together a 4-year academic plan. It's supposed to look at, we don't have everything written in here, but if you do look at the statute, it's got a nice list of all the things that should be included in the 4-year academic plan. And we have some of the information about courses, looking at career and technical courses, and even looking, and the default is actually to ensure our children try to graduate within 4 years, as well as set them up for, if they do want to take advantage of the Governor Gwynn's Millennium Scholarship, it sets them up to be able to do that. So that's what the default is, to be able to move forward, and then again continues to be adjusted as the child goes through high school. What's nice is, again, this was added not too long ago, that we have to look at a policy for identifying children who are in care. And I will say we've made lots of strides in that way. Donna and her department has been amazing at making sure that our kids are identified as being in foster care. And then what we're supposed to do is review each academic plan to maximize credits. This is something that has been a very recent, it was passed 2 years ago in SB 147. And now there are actually state groups that I've been involved in, and we've been involved in, to look at maximizing those credits. So that can be anything from, you know, if the kid has had some seat time, if, you know, can we give them partial credit for that? Can we combine certain assignments to give them credit? So there should be a rollout of what this actually looks like in the next short period of time. But as an advocacy tip, when we have kiddos that are failing or look like they are failing in high school, what we can do is set up a meeting. The school is supposed to set it up, but I'm also trying to tell our folks, DFS, CAP attorneys, anybody who is a volunteer educational advocate, as well as EDMs, to look into and setting up meetings with the schools to discuss this, to see what we can do to try to maximize the credits of the child.
Leslie, I think this is your last slide for this run.
Oh, okay, yep. And so I'm so sorry I moved. So again, what should happen is that parents should be notified of the plan. This happens sometimes and sometimes it does not. However, in Infinite Campus, there are actual plans that are in there, so you can actually look to see what the actual course of study is. You can ask a school, if you're a volunteer educational advocate or EDM, what is the academic plan for my child, and get a hold of those. You can see how the child's actually doing within the credits. So parents are supposed to be invited. We've also asked our DFS workers to be invited to those meetings so that they can work in consultation with the school for the plan. There's actually, parents have to actually sign the plan. So again, if you have not had that, you can ask what the academic plan is for the child, and then it's supposed to be reviewed once a year. So, you know, that is where you can find out from your child, or make sure that the child has met with the counselor at least once a year, to ensure that the child is moving forward to whatever graduation that they or every diploma that they are slated for.
And then Assembly Bill 156 was passed in 2019. It's now housed in NRS 432B 462. It expanded the number of cases where non-parental education decision makers can be appointed for children. And it also outlines the duties and responsibilities for those educational decision makers. So the next two slides are a lot of statute, the things that I'd like to kind of draw your attention to, and then this will just be here as a reference for you in the material we're going to send you after the presentation. It's important, you know, here is a list of the people who should be the education decision makers. So in 2, there's a rebuttable presumption that it's in the best interest for the parent to be in that role. And then if the parent's not available, or guardian, then we have in 3 a list of other people who might be best suited to make those decisions for those kids. And I think it's important because we do have our volunteer education advocate program, which Ilka runs out of our program, but that's a very limited resource. And if you think about who should be making decisions for a kid, we would rather have it somebody who has, you know, previous knowledge of the kid, knows them. We want to preserve our volunteer education advocates for those cases where we really don't have anyone else. In courtroom 11, I noticed that Judge Tootin was really started to address education decision makers in every court hearing. This past like February and March is when he was, really on it. And I feel like in every hearing, he is on top of this issue so that education is getting discussed, even if it's just who's making decisions. And then who is the best person might change throughout the case, right? So our kids are in a state of flux, they're in child haven, they're in a placement, they're in RTC. Okay, we may have a volunteer education advocate, but then when we get them into maybe an adoptive resource or a more permanent home, maybe then it's time to consider if we should still have that VEA on the case, or should we be switching to an education decision maker who's the placement or the adoptive resource. And of course, that's going to need to be addressed by the judge because we have a court order making the VEA the education decision maker. So we'll need another court order to change that. And then this slide, the big thing, I think this is where we need to go and we're getting better at. As you can see in number 7, educational decision maker shall, right? So they shall do all these things. I think we're getting there. We're probably not there yet, but if you ever need to look at what the education decision maker should be doing under the law, this is where you're going to look. And we're getting there. We're getting better trainings and we're getting people more involved. And then here, again, the court can change the education decision maker, but that's also our department supports, our client is the education decision maker for our department, and we're going to support whoever that education decision maker is. So if, sometimes we'll get a call when the court appoints an education decision maker and they had previously had a volunteer education advocate on the case, and we'll get calls from caseworkers saying, we want to stick with the volunteer education advocate, right? Well, that's not our decision on our team to make. The judge has made that decision. So you either need to argue when that decision is being made, or if the person the judge has appointed is not going to meetings or not doing what they need to do, then you need to either have a stip and order to get back on calendar to explain to the judge or file a motion. Obviously, if it's one of our volunteer education advocates, Ilka's in constant touch with them. So if there's an issue with them not attending meetings, you would want to loop us in and we would address that right away.
Jonathan, this is Bridget. I want to jump in on the educational decision makers and maybe have Ilka kind of talk about the process. I know we're here today to give an overview of the law, but I know this is a brand new process, and perhaps we should, if Ilka can talk about how things are going and what's going on with the educational decision makers, and then we can maybe have this little bit of a conversation and take questions at the end. Ilka?
So we are seeing that different courtrooms are doing different things. So what I will say is if you do hear, let's say if our cap attorneys are sitting in on PCs and you hear something where a judge brings up that an education decision maker will be assigned through legal aid, if you could just alert me. I know Candace had a case the other day and she sent an email to our team letting us know, hey, I was just sitting in the courtroom and heard the judge say this. So if you get any of those, please send it my way, because sometimes the judges are asking for a volunteer education advocate to be assigned, but it doesn't necessarily come to me directly. So if you hear this in court, or if you have questions about assigning a volunteer on our end, just loop me in at any point, and I will either reach out to pro bono if I need to look into talking with the cap attorney, if it's through pro bono, or the DA directly. But yes, different things are happening in different courtrooms. So just keep an eye out if a judge is asking for a volunteer through our office, that it is coming to me somehow.
And
Bridget, is that what you wanted me to repeat?
Right, and it's because the courts are the ones that are sending the referrals out to you, but sometimes they don't get to you. Is that correct, Ilka?
Correct. So sometimes the CAP attorney will receive the court order and then I will get them, but I don't necessarily, like if it's filed under sealed confidential, I don't get those. And the CAP attorney might not receive that either. So when the assistant's going in to check Odyssey, they might not have access to view that file. So just keep that in mind as well.
Right. So this is another, so because it's a brand new, well, it shouldn't be brand new. It's been around for a couple of years, but the courts aren't used to doing it yet. And so there are some hiccups. We have 6 different judges who do things at least 4 different ways. And so just so that people listening to this CLE right now understand that the team of the child welfare team from my office and DFS, as well as legal aid, which will now be Jonathan because it was me and Kelly before, we'll be going to the judges to try to get some consistency so we do not miss out on things, as well as making sure that our new statewide orders are available in the system for everybody that address these EDM issues. All right, go on to 210 now, Jonathan.
And I was just gonna add, ooh, my internet connect. Can you guys hear me? It says my internet is unstable. Okay. I do know, one of the judges just reached out to me and we're gonna have a conversation this afternoon about potentially anytime a VEA is appointed that I'll be a service contact for the case. So then, I'll be notified. I can forward that to Ilka and that seems like that's not the solution yet, but we're starting that conversation. And I think that could go a long way in not having cases slip through the cracks. And another example, we don't necessarily have a CAP attorney on every case, and there may not be a CAP attorney at the very beginning of the case. So if a VEA is appointed and there's not a CAP attorney on the case, our office is not finding out about those cases. And so I think if we did something like a service contact, we would get around that. So we're working on a solution for that, and hopefully we get something soon. So SB 210, this was new this legislative session, and it's going to require the school district and out-of-state or RTCs to coordinate on the child's IEP and services. How this is going to actually roll out, I don't think we, in practice, I'm not sure we know that yet. We have had CCSD being involved on transition and discharge planning already in cases. So I know that my team has had at least 2 cases where we have had CCSD involved in that discharge planning. I think that's really important. There's another slide that gets into why, but if you have a child who's placed at Miley and then they get sent to an RTC, well, if they're at that RTC for a year, the reason we send them there is hopefully that they're addressing some of their mental health issues that might have contributed to their placement in a school like Miley. And maybe when they come back, that's no longer an appropriate placement, right? Whereas in the past, we would just say, well, you were there when you left, that's where you're going to go when you come back. And I think, having that discussion about maybe a less restrictive placement being more appropriate is really valuable.
If I can jump in on that one too, Jonathan, on 210. All right, so I just wanted to add, when this bill went through the legislative session, the burden of this plan is on the psychiatric facilities and CCSD. They are supposed to, of course, include the Department of Family Services in that planning. But in order to enforce that statutory requirement for them to create this plan, it could require filing of motions to join, which would not only just be our state facilities like Desert Willow, but also any of the other RTCs that we have in state, because they could be, because they are a person by statute that has a legal responsibility to a child. So this may require some motions to join in order to get the care facilities to participate. The hiccup we're going to have, and I put this out there, so all of you brains in the room could think about it, is what are we going to do when our children are in an out-of-state RTC, and how are we going to be able to enforce this requirement on another jurisdiction? So There may be some issues when we send our kids out of state with getting them, hopefully not. The other intent of this law is not to hold up children from being placed in RTCs. So the plan does not have to be in place prior to the child being placed in the RTC. All right, thank you.
And then another addition from this legislative session is AB 194. So this just goes through and kind of requires the district to provide information on restorative justice and their discipline procedure. And then, and what I think is important is they have to clarify any appeal process they have for appealing suspensions and expulsions. And the punishment for appealing cannot be increased. So, I think there was testimony in the legislature that previously the schools were using the idea that your kid could get a worse punishment for you exercising this due process right and appealing, and that put parents in a very difficult position. So it's clear now that you can't get a worse punishment for appealing. And then while the appeal is pending, you should still be being educated in the least restrictive environment possible. Leslie, I had you on this slide. I don't know if there's anything you want to jump in with.
Thanks, Jonathan. I appreciate it. So yeah, just to add, the nice thing is we never had an appeal process for suspensions up until now. So this is a kind of a big deal that if our kid is erroneously or there's mitigating circumstances that we want to bring up about suspensions, this is going to be, they have to put together a procedure for what that appeal process looks like. So that's great. In practice, I wonder how that's going to work because, it may take a little while past the suspension, but at least a lot of us I know work hard to try and get suspensions off our kiddos' records. And so I think that this is kind of exciting. It's a little scarier too, because there's now, we've finally codified, unfortunately, permanent expulsion. This is something a lot of us were fighting against, but the good thing is which I know Maury is going to talk about next slide, and I'm happy to pop in. We have some extra protections in there. So while we could not necessarily get rid of permanent expulsions, and permanent expulsions does not mean officially permanently expelling a child, but what it means is they can't go back to a comprehensive campus, which is an issue. But unfortunately, and legal aid and all of those out there too, in the next legislative session, we did have something now stating that schools are not necessarily required to provide education to these kids, but schools may offer the education. So hopefully in practice, I know in speaking with a lot of my CCSD colleagues, they've mentioned that hopefully the education will be provided for these kids, but there's nothing statutorily that requires education for a kid that has been permanently expelled. So we have a circumstance where some of the punishments have gotten a little bit more punitive. So we're glad to have some of the restorative justice components and also some of the protections also for our most vulnerable children, like our kiddos in foster care. But it's a little bit of a scarier landscape right now.
Absolutely, I couldn't agree more. I know this last session was education has been becoming front and center of session, and we're grateful for SB 354, which did successfully pass kind of as a counterpunch to AB 67 and the permanent expulsion. And Bridget, feel free to chime in on this one because I know you are fighting this tooth and nail for us. SB 354, we're grateful to Dr. Tammy Malich for allowing us to add foster care to this bill. Initially, it was created to kind of have a mitigating circumstance for before a child may be suspended or expelled from school, their homelessness must be considered a factor as a mitigating factor to ensure that homelessness was not a cause or didn't have a nexus to the behavior that resulted in the extension or suspension. We tried to bootstrap and throw in foster care on there because our children are extremely vulnerable, and we wanted to ensure that our kids are not being suspended or expelled due to behavior that actually is the source of them being in foster care. Perhaps they were just removed the night before and they were, very tense, or, just sky's the limit on what the factors could be. And so we're very grateful that Tammy Malich went forward, fought this tooth and nail for us and with us and all of our stakeholders that went forward. This bill has become law. I believe it's effective, I want to say 2022. I'm not sure. I think there's plans and things that are getting in place. We're giving the Board of Trustees some time to establish their plan, but we want to definitely equip the arsenal, which is you guys and caseworkers, cap attorneys, everyone, to ensure that, we're adequately already providing those protections for our kiddos so that in the event they are targeted or identified as having to be suspended or expelled, there's an advocate at the school, the foster care advocates. We should be working closely with them because they're the ones that are responsible for making those determinations about whether or not the behavior that led to the infraction was caused by homelessness or being in foster care. And the presumption is in our favor. So that's actually a really good start. Bridget, did you want to add anything to this one? Because I know you are highly involved in this.
No, I think you covered it. I just want to make sure that we talk about permanent expulsion. There's federal mandates for permanent expulsion, and those are the only ones that now apply in our state statutes. So it's not, it was a big battle on AB 67 because they wanted to expand when we could permanently expel children and not be required to educate them. One of the grounds I know for a fact for permanent expulsion is a second offense weapons on school property. So it really has to be a pretty serious offense to get to that permanent expulsion. And then, like Leslie said, they can then offer alternatives to education, including online school. Not run by the school district, though.
So I'm going to try to make up a little bit of time so we can get through all of our slides. So individuals with Disabilities Education Act is just that every child has the right to be educated. And then this next slide is free and appropriate public education. You can read through those at the public expense, has to meet state education standards, be in conformity with the IEP. You know, one analogy I always hear about this, I don't like the analogy, but it is that you get a Chevrolet, so you get a mode of transportation, not necessarily a Cadillac. I don't really know that I 100% love that, but I always think when we go into meetings, we should be trying to get our Chevrolet really good tires or like some additional features, and that's what I see our team that we're trying to do. And then I'm going to turn it over to Ilka.
Thank you. So something that we can request right away is response to intervention, and the school will refer to this as RTI. So if we ever want to initiate like a special education evaluation or a 504 plan, the first step the school will respond for the most part is saying that they would like to implement RTI, which an example of this could be a student that's struggling in reading, and the school offers to put them in a small group setting for 30 minutes per day in the content area of reading. Keep in mind that if the school offers to conduct RTI or implement RTI, this does not replace the evaluation. This does not replace a 504 plan. So you can still move forward with those accommodations, but the school will want to track data and pull progress reporting from this RTI time, I should say. Next slide. And if we do feel like a student needs special education services, the first step to requesting an evaluation would be the education decision maker has to submit a letter to the school principal. At that point, the team will determine if the evaluation is warranted at that time. Like I said, they might need time to pull data, so they'll request that RTI. But also keep in mind that if the school chooses to move forward with the special education evaluation, the EDM will sign the CCF 555, which is the consent to evaluate, and the school then has 45 school days to conduct that assessment. And I'm going to cut it short because I know that we're pressed for time.
And I'm going to do the same thing. So again, you know, there's laws out there. We want to make sure that when kids come into care, that there is a parent. A lot of school laws, a parent is the one who advocates and makes the official educational decisions for a child. So originally, which is actually very exciting, and Legal Aid did a great job, we are allowed under IDEA, so anything for special education services, it was allowed that either the school district or, in Nevada is one of the only jurisdictions that allows for the family courts to assign an educational surrogate. The issue with that is that was only over special education, and special education could be in the evaluation or in getting IEP services. So that is where we have surrogates. And so Legal Aid Center started the surrogate program that Ilka is now running. Since then, I know that we've kind of changed it. It's not just about being a surrogate, and it's always been an interesting topic back and forth about the name surrogate and what that means. So Now we have the volunteer educational advocates who are trained, and they originally were surrogates, but now we have a much larger expansion of parental rights, and that's where we have our EDMs. So EDMs have a much broader, just so there's so many different terms going back and forth. EDMs technically are either the surrogate, they become the surrogate that's subsumed under an EDM, so they do make the rights for special education, but they also, Jonathan showed you the slides, and the slides are in here, have a much broader sense of what they are. So they would actually be the surrogate, and then, you know, again, that they are VEAs. So Ilka, if you want to go to the next slide, just trying to kind of explain it a little bit more. And so the idea is an EDM encompasses everything. An EDM could be either a volunteer educational advocate, although the presumption is the parent, and then either the either the VEA or the parent acting as the EDM are also the surrogate, so they're going to make all of the decisions for the child. So I just wanted to kind of make it a little bit clear when we use different terms. So EDM really encompasses a much larger decision-making ability.
So if you find that your student or the client that you're working with needs a volunteer education advocate assigned to their case, please send me the referral form. Carmen will be sending out our materials, and included in that is the referral form. So the referral form comes directly to me. We also need the court order. So prior to assigning the case to a volunteer, we need the cap attorney or the DA to submit the EDM court order. At that point, once everything is finalized, I will receive the referral form along with the court order, and then I can match the volunteer to the case. Please make sure that if we are assigning a volunteer to the case, you're keeping them involved, you're keeping them in the loop, also working with them and collaborating with them, inviting them to meetings, CFTs, TTMs, court hearings, you name it. But these people that we're assigning, the volunteers, should be actively involved on these cases, and they will remain involved on the case until either the student has a foster parent who wants to act in this role, the parent, the relative, fictive kin, the student turns 18, which if the student does turn 18, we can still assist them. My colleague Anthony McKinsey in our office, he assists our youth that are aging out, so he can assist them directly and they can make decisions on their own. We also will withdraw the surrogate on our end if we find that there's someone else more appropriate, like Jonathan talked about earlier. But yes, we only close the case on our end if the case actually closes or if there's someone more appropriate to act in that role. And so what should you expect from our VEAs? Please, when you receive the introduction email, so Patricia through our office, she sends an introduction email letting everyone know that the volunteer has officially been assigned to the case to act as a student's education decision maker. At that point, they can start their advocacy work. So the school district has received notice that this person is now actively involved. Please, share an overview with them. Give them a brief, history on the education side of things, and kind of guide them with their advocacy role. Like, what should they be looking for? What should they be advocating for? They do have access to reviewing the records, and I will do that with them, but they should be also attending IEP meetings, any school-based meetings, and then making sure that we're ensuring these students' best interests are being kept in mind. And then also the last thing I forgot to mention was if a student qualifies for an IEP, when they have their multidisciplinary team meeting, they will have to reevaluate every 3 years. We ask that once the 3-year mark comes around, sometimes schools ask to waive that. We ask to just push forward with that evaluation. It's good to just get a new, refresher on the kiddo and see what's happening 3 years later. So keep that in mind, that the reevaluation should be every 3 years. And then these are some things to look out for. If they do move forward with that evaluation, they may assess in these areas. They might not assess, but this is an option. So if you do think that the kiddo needs maybe even, health assessment, please make sure that's already a given. They'll do that. But maybe, we wanted to like an additional speech assessment. Those, might not just occur, because they're doing the assessment. So make sure to ask for these additional assessments if needed. And then once the evaluation is completed, the school will hold a multidisciplinary team meeting to determine if the student qualifies for services. Keep in mind, after that, if they are eligible for services, then we will hold an IEP meeting and we will create an initial IEP. The IEP is like a contract with the district, so it should be looked at least once a month. They will hold an IEP meeting, once a year, I'm sorry. They will hold an IEP meeting at least annually, but that doesn't mean that the meeting has to wait until their yearly review. You can ask for an IEP meeting at any time. So if you see that your student is struggling, let's get on it right away. Let's not wait until the end of the school year or until the annual meeting to address that with the school-based team. And then the last thing about the IEP is the IEP should have measurable goals. So if the student, like I said, has a deficit in reading, let's make sure that their IEP goal is measurable, and then they have benchmarks that are achievable within those quarters. On the next slide, I give an example of a goal and the benchmarks, but keep in mind that also we want to include if a student needs related services, transportation, speech therapy, occupational therapy, physical therapy, all of that also should be included in the IEP. And also keep in mind that, Jonathan, you can switch to the next slide, but if there are outside providers that are supporting this student, make sure to include their feedback. If there's a speech therapist, I have kiddos that are placed at Neuro Restorative for Kids, the speech team over there and the therapist team over there, they usually love to come to our IEP meetings because then they provide the outside support services to the school. They let them know what they're working on with the student outside of school, and then they'll hopefully incorporate that in the student's IEP so that the speech therapist in the school setting can also work on things similar and things are cohesive inside and outside of school.
So what to expect from your EDMs at IEP meetings. So this is just what we expect from our volunteers and hopefully from all education decision makers. What I want to kind of just draw your attention to is bring someone with you. And if anyone's ever sat in on an IEP meeting, there are numerous school professionals, and then there's, a parent or an education decision maker. And, sometimes when you have all these professionals on the same page and you might think something different should happen, it helps to have somebody with you. And on our team, that's going to be our advocate. So Ilka or Anthony or Amy. So I think that's really important to have somebody there with you to balance the table. We talked about this a little bit before when in reference to when a kid comes back from RTC, we want to make sure that they're getting back in the right placement, not just the placement that they left. It's easier to go down to a more restrictive. It's harder for us to push back up. So I think it's really important, just to keep that in mind. They may say, well, let's just go to a special school and then we'll reevaluate and move back up. Your response should be, no, let's evaluate where we are and then decide, because it's harder to move to a less restrictive environment.
And just to add really quick, we have a lot more protections now, like we talked about restorative justice. We're hoping that we don't have to get to a Miley or a special school. We're putting these restorative justice practices in place on the comprehensive campus, and we look at all of those settings before we get to that special school. So keep that in mind. If a school is ever talking about changing your client's school placement, if you have any questions, please feel free to ask our team. We would love to attend those meetings or just, kind of review the case with you and kind of go through the records to see if that is appropriate.
This one, the key here is if it gets to the point where you're disagreeing on what happens, then our team has to be looped in, because it's at that point that we'd be able to file a due process and, take additional steps outside of that IEP meeting to make sure that our kids' needs are being met. And then, so the thing that's not on here is cash. Okay. So we sometimes are, parents or some people we support want money. This is what we are trying to get when we file a due process complaint. And I'll draw your attention specifically to compensatory education. So this is going to be one-on-one education, and it'll be an hour number. So for some of our kids, we'll get like 90 hours of comp ed. And that's one-to-one kind of like tutoring, but it's focused, it's outside of the school hours, and it's focused on meeting those goals within the IEP.
And then something to keep in mind, if our students do get in trouble that have IEPs, let's make sure to keep a close eye on this. Historically, the school has kept them out of school too long sometimes when they get in trouble. So just keep an eye, constantly follow up, or ask the education decision maker to follow up the school every single day to kind of determine when we're going to have that reentry meeting or when we're going to have the manifestation determination review. If a student has an IEP, they have extra protections. So they will have to hold a manifestation determination review. They asked 2 main questions that's written right here on this slide. Was the conduct in question directly related to the student's disability, and or did the school fail to implement the IEP properly? If either of those questions are answered yes, then it is a manifestation of the student's disability, and the school will then have to reconvene an IEP meeting. They'll have to conduct a functional behavioral assessment. They call them an FBA, and they'll also have to implement a behavior intervention plan, which they refer to as a BIP. Keep in mind, if a student already has a BIP and they weren't following that BIP, that is also going to be a failure to implement the IEP, because the BIP is an attachment to the IEP, and that's included under the accommodations section in the IEP. So keep in mind, if you have a meeting like that, also include our team, and we will definitely attend those meetings with you.
On discipline, all discipline is not created equally. So there are special rules for weapons, drugs, and if there's serious bodily harm. And, you know, I think Bridget and Leslie both mentioned that the discipline structure has changed with this past legislative session, and we do not have that reflected in this presentation, but there are a lot of changes to that part of the statute. And then bullying, here are just some resources we just wanted to include on bullying. And then Leslie.
You got it. I can. Ilka, did you want to do 504?
Sure, either way. We'll just do this. I'll do it quickly because we're pressed for time. A 504 plan can also be requested right away. So if you do think that a student needs additional support and services, like I said, that RTI can be requested immediately, as well as the 504 plan. So what we do sometimes is we'll request a special education evaluation, and the school has that 45 school days to conduct that assessment. So if the student needs immediate accommodations, we'll request a 504 plan to be implemented while that evaluation is being conducted. Now, keep in mind, a 504 plan might be all that the student needs. So the 504 plan stays within the general ed setting, and it's accommodations that can be asked for, like extra time on assignments, extra time on tests, preferred seating, smaller group instruction, or able to take tests in smaller group settings. That kind of stuff can all be requested immediately. So just keep that in mind, and the request would be made through the school counselor. Leslie, you want to take this one?
Sure. So some of the big differences, again, between IDEA versus 504, just so you guys know, when you do get a 504, there has to be a medical diagnosis. So in order to get a 504, you have to have something medically there. If any kids are seeing counselors or anything that they're seeing a professional, there usually is a diagnosis. So you just need to get that information from them. So you have to have that, and it's just accommodations. There's no removal. It's given by the general ed teacher and through the general ed curriculum. So if you feel like a child just needs to, again, have barriers removed, a 504 is appropriate. If we're looking for a child who needs to be taught something or have an individualized education plan, that's when we're looking at IDEA and we're looking at an IEP. There are 2 categories under IDEA and to get an IEP that you do not have to have a medical diagnosis. The first one is specific learning disability. That's something that they will take the data to figure it out. And also serious emotional disturbance. If a child has a behavioral or emotional disability, you can do an evaluation under that category and they can receive services without having a diagnosis. So I think that's really important to know. So if there's any resources that you need to pull a child out for extra resource, you want to put them together for an education plan and give them a really comprehensive plan and teach them, that's when we're looking at IDA or an IEP.
Okay, so we wanted to make sure that you all knew that there were certain statutory requirements for DFS when it came to a child's education. So we listed them out on this slide, and then Jonathan, everybody can review this later. And then on the next slide, I want to point out a couple of very specific things. So first of all, on the second bullet point, providing counseling services and other services to pupils and staff. That was put into statute in 2017 as a request of Washoe County. That only applies if the school experiences a crisis, emergency, or a suicide. So in Washoe County, they had a series of crisis, emergencies, and suicides, and they wanted the school administrators to be able to reach out to the child welfare agency in order to bring in counselors for staff and students. That is very specific to those types of situations for schools. And then the determining whether it's in the best interest of the child to remain in his or her school of origin is found in the education statutes and not in our regular 432B, as well as providing that transportation to the children along with the school district. We work in conjunction with the school district as well. And then finally also found in the education statutes is that single point of contact to work with the Department of Education to develop some policies to comply with requirements of ESSA. Next one. So this specific to EDMs, we are very grateful from an agency perspective that we have the support. From doing these cases that a lot goes on. We have to look out for parents, children, relatives, and so having that extra support on something so important as education is very helpful. So we have a requirement of our staff to attend academic planning, disciplinary meetings. We have directed them that they cannot waive the appeals for suspensions and expulsion processes. You can't say, no, my child doesn't want to appeal it. That's not their decision to make. IEP meetings, manifestation determinations, 504s. We tell them they need to attend these meetings. Of course, if they are unable to attend for other emergency reasons, then they are to get the information from whoever did attend. They are to collaborate with you all on educational issues, review educational records, don't just attach them to court reports, but know what's in them, and notify the EDMs of court date and their categorizations. Mari, did you want to add anything? Because I know you're on that slide with me. I'm just trying to move.
No, you captured it perfectly. And of course, our single point of contact is Dr. Leslie Murdock. We stole her from CAP, from Legal Aid, and she is, for all intents and purposes, our point of contact for education liaison.
And then Leslie, this one's.
You got it. So again, we just want to let everyone know, because I think there's a little bit of a misconception that every single person in DFS has access to Infinite Campus. We have an agreement with the school district that only people who need it, as well as a certain group of our folks have it. So we do have key people in DFS that have access to it. And again, if someone needs access to school records, they can contact, again, supervisors or folks within there. So we just want to, because I think sometimes there's a misconception that every single person has access, that they do not. We can have access, but not everybody has it in our agency because of our agreement with the school district.
And I'm just gonna, what you can do in your role in your advocacy, you guys can read this because we were short on time, so we're gonna flash through. This is just bringing it back full circle to how important education is for our kiddos. And then Mari.
And that's a wrap. Education's important. And you know what? Our kids have fee waivers now. They can go to college and it's paid for. So it's our role right now to just really equip, come together, collaborate so that we can get the kids the best Cadillac, the best Tesla out there so that they can go and sky's the limit and do even greater things. So thank you. We made it.
And then our, here is all our contact information. We want to respect your guys' time, so we don't want to go past 1. I know that's been kind of the MO of a lot of these CLEs, is to drift past 1. So if you have questions, I'm happy to stay on. And then obviously we have our email addresses here for points of contact. What you need to know is if there's an education issue, you don't need to be equipped to handle it, right? We're here to support those kids and make sure that they're getting what they need. So, reach out to anyone on my team and anyone on the department's team.
And John, we did have a question from Janice in the chat room. She said, too many placement conditions placements condition placement on going to the zone school, often without DFS being told about the condition. No ESSA meeting to discuss. What to do here? So who wants to take that one?
So I think that it's an extremely difficult topic to tackle because the kid, once they're placed in that foster home, and I think this is the problem, is that foster parent, even if it's not a requirement, right? If I've had kids go into foster homes and then the foster homes convince them that they should want to go to the zone school, or it could just be that the bus ride is too long and they're getting up too early. And I don't know if we had it in these slides or if we cut it, but kind of if it's 2 hours, or less, that's not, I think that's an okay bus ride. If it's over, then we can push back. And so, I've had kids that were excelling in their school, and then they ended up switching because the bus ride was too much. They were, I had one kid, he was out at St. Jude's and he was supposed to be attending Desert Rose. And, I think he was getting up at 4 a.m.
Well, John, the issue is, like, for example, a young kiddo is very adamant about wanting to go to their home school. They've been there. The placement tells them they have to go to the zone school and they have to suck it up. They want to go to the placement, and then the placement disrupts. And that's the pattern of how kids end up in 10 different schools, because the placements disrupt and the kids are forced to suck it up every time. I have one now where Judge Tootin ordered the client placed at the school of origin because he was very adamant about it. Foster care told me that he had changed his mind and wanted to go to the zone school, and she went and enrolled him in her zone school, and he doesn't want to go to the zone school. So now a school started. So I don't know what DFS can do about this, but it almost seems like the higher level of care places are making end runs around the department. And that's what happens. I mean, the DFS foster parents seem to know better, but the higher level of care foster homes seem to have a knack of end running the department and not telling them about this precondition.
And Bridget, I don't know if you're muted right now. I know sometimes we have.
I know I think it's tough. I don't know how to. I mean, obviously, we're not busting at the seams with foster homes right now, so that we can, start shutting people down and not using people for, bad behavior like this. I really don't. I mean, it's disappointing to know that a foster parent would do that. I understand. I kind of expected it, of course, right? Because it's not just like going to the zone school. It's like for everything that the child does at the school, it's a matter of the foster parent has to go to, if you live in the north and the zone school's in Green Valley, like every time they have something going on at the school, an activity after hours, everything like that, foster parents got to travel all that distance. So I figured it was going to create some havoc, especially for relative foster placements, right?
Well, sure, but the federal statute requires a meeting. It requires everybody to get together and discuss. ESSA does. And the state statute requires DFS to ultimately make the decision after taking everything else into account.
Right.
So minimally, I think we need to figure out ways to at least enforce the law so that there's at least a discussion, so that ultimately, if it's determined that it's in the best interest for the child to go to the zone school, at least all the considerations are out there and not just the convenience of the foster parent.
Right, absolutely. And I don't know if maybe, Leslie, if we can work to figure out how to report these, right? So if this is something that's occurred, would this be something that's reported to Leslie so that she can make sure that ESSA meeting is occurring, that she's discussing it with the permanency worker or supervisor to make sure that we've done what we need to do? Because I agree, DFS is the ultimate decision maker, but they should be making that decision based upon all the best information available.
Correct. That's my point, is that they're being, and I have it where DFS was just end run. They're not being told until after the placement is there.
Right.
So
they should definitely loop us in. We've had managers in the past contact us with these types of scenarios saying, what do we do with that? Do we listen to the foster parent? And we said, absolutely not. That's one of the factors that can be considered, because of the placement and the role, the relationship with that foster parent. But ultimately, there's several factors, and the presumption is that keep the child at their school of origin is the best interest, unless it can be rebutted. So, absolutely have Leslie be looped in, or Janice, if that in that case, if Leslie's not already looped in, and we'll also do our part to speak with the permanency licensing side of the house.
Okay, thank you.
It does put CAPS in a really difficult position, because usually once a kid has switched and you find out weeks later, switching them back is going to, a lot of times my kids have then been fine with it, right? But part of that is they're used to just being like, oh, I'm fine with what's going on, right? I'm buffeted by all these things outside of my control. And so there's really no rolling that back once it happens. And I think that's where the frustration is there's, and I guess maybe reporting and getting some data might be a starting point, right?
And
because
John,
if they do that end run, there's nothing, often the kids don't want to then unwind that, at least on my cases.
And Jonathan, from a practice standpoint, Donna has been, and the CCSD has actually been pretty great in working with us. So like if it happens erroneously, again, to your point, if it's many months down and now, or a certain amount of time and the kid is now moved and there's a change in heart just because now that child is settled sometimes. But Donna has been really great. We have had some situations where that's happened. And I think Ilka, you've done this as well, where we've contacted Donna saying this happened erroneously and this is not what was supposed to happen. And so from a practice standpoint, Donna has worked with the schools to get the child back. So if that is ever a situation from a practice standpoint, Donna has been incredibly helpful in looping her in, has made a big difference too.
So I guess we should add that to the slide of things our team can act on right away, because, just like whether it's not having the school records or having this erroneously done, maybe we should be notified as soon as a CAP attorney finds out about it, and we can reach out to Donna.
We did have another question. It's when should the CAP attorney be bringing a motion for an education decision maker to be assigned? General guidelines.
So I think it should be I don't know that you need to file a motion, right? The court should just be addressing this in a hearing. Now, if you're in a situation where, we have a kid who needs to start getting assessed for an IEP, you may not want to wait, right, for the next hearing that happens to come on the calendar. And I would hope we don't need motions for that, right? That's a stip and order or stipulation to put on calendar and have the judge appoint one. I would hope that our judges, are willing to do that. I know courtroom 11, certainly that's just a stip and order. Once we have the order for a VEA, we can go ahead and take those steps. So it just depends. If you have a hearing next week, just bring it up in court. If you don't have a hearing and it's something where we need to start this evaluation process, get a 504 in place, then there's some urgency there. So I can't tell you a timeline, but if it's an urgent thing, then you need to do a stip and order. And if for some reason that doesn't work in your courtroom, then a motion.
And those were all the questions in the chat room, but were there any other questions?
All right. Well, thank you, everyone. I'm going to stop recording. If you do have questions or things come up, you've got our email.